My name is Elizabeth, and I'm the legal advisor and project lead for the DPRK projects at GRC, Global Rights Compliance, and I'll be moderating today. I'd like to thank firstly the National Endowment for Democracy for its generous support of the event, and also our state sponsor, the Republic of Korea. Thank you for the event. I'm also delighted to introduce our partner and co-host, Transitional Justice Working Group, or TJWG, a leading organisation with expertise on abductions, arbitrary detention, enforced disappearances and other mass atrocities committed by the DPRK regime. Today we have a distinguished panel of experts who I'll introduce in turn. The composition of the panel changed last night in the events of the martial law that was declared in South Korea yesterday, which is now being reversed, which meant, unfortunately for us, we were not able to have the representative of the Republic of Korea attend and be on the panel with us doing opening remarks. But we are very privileged to have some representatives here today, and we're very grateful for that. In place of the representative on our panel, we have our Vice President Catriona Murdoch, who kindly offered to step in their place. This panel today, as the name suggests, will be addressing the grave systematic human rights violations occurring in North Korea and potential opportunities for accountability and justice through the different pathways of the ICC and the ICJ. The panel will explore the different challenges and possible solutions of these avenues, and we will also hear from Mr. Lee, a North Korean escapee, about the inner workings of the DPRK state security structure. We have a camera here filming the event. If you're not comfortable with being on camera, please let April at the back know, and we'll make sure not to include you. And just a quick note, we also have, this room didn't allow for simultaneous translation services, so we have our colleague Yeji translating or doing simultaneous interpretation on the computer for Mr. Lee. So I wanted to start by briefly outlining GRC's work in the North Korean human rights space, and then Catriona will elaborate on that later. And I also wanted to provide a bit of an overview of the developments of the North Korean human rights situation currently. GRC is an international law and development foundation, and since 2020, our team has been involved in implementing projects that seek to pursue accountability for the crimes committed in North Korea. We've been working with a number of local organizations, including TJWG, who are based in Seoul, focusing on documenting human rights abuses, conducting advocacy with governments and international justice mechanisms, as well as the different UN bodies. And we've also been exploring different potential pathways by which to hold the North Korean regime to account, looking at the ICC, the ICJ, but also universal jurisdiction pathways and soft law mechanisms such as sanctions. Catriona will be talking a little bit more about our work later on. This year marks the 10th year anniversary of the landmark 2014 UN Commission of Inquiry report, which was it's a groundbreaking report for the North Korean crimes committed there. The report stated that the gravity, scale, and nature of these violations reveal a state that does not have any parallel in the contemporary world. Despite 10 years passing, little concrete action has been taken to curb the systematic human rights abuses and crimes committed by the Kim regime. The human rights situation has further deteriorated sharply since COVID-19, when the government imposed strict regulations which resulted in further restriction of movement and trade and the curtailment of people's basic freedoms. These measures have tightened the government's control over virtually every aspect of people's lives, and additionally citizens are exposed to arbitrary arrest, with thousands detained in political prison camps, and enforced disappearances, torture and unfair trials to maintain obedience. The government is now more isolated from the West and the UN system, more repressive and more brutal than ever before. Outside of North Korea, the regime continues to strengthen its ties with Russia and China, threatening regional and global security. China continues to carry out mass forced repatriations of North Koreans in violation of international law, knowing full well that upon their return, once they're repatriated, they may face lifelong detention, torture, severe sexual and gender-based violence, and possible executions. North Korean nationals continue to be sent as part of the extensive state-sponsored forced labor programs to China and Russia, and we're seeing that this is increasing. And earlier this year, Russia and the DPRK signed a comprehensive strategic partnership to expand cooperation in military matters, as well as trade, investment, cultural, and humanitarian aid. Worryingly, we've also seen the stationing of North Korean troops in Russia as part of their potential involvement in the Ukraine conflict. We're yet to see how that pans out, but we're keeping a close eye on that. And there's been an expansion of the nuclear weapons program. In addition, there's been a huge blow to international efforts with the Russian veto earlier this year in March, which ended the mandate of the UN Security Council panel of experts that was set up to monitor the enforcement of UN sanctions on North Korea. The actions of DPRK, both within and outside North Korea, continue unabated, and the impunity of the Kim regime has long-lasting impacts on the international justice and peace. There have been a couple of positive steps this year in 2024. We saw earlier in the year that North Korea participated in the third round of the Universal Periodic Review of their human rights record, and that was an active participation of North Korea. So we're yet to see if any of the recommendations will be implemented. And additionally, in April this year, the UN Human Rights Council adopted a resolution boosting scrutiny of North Korean human rights and highlighting the link between the human rights situation and also the nuclear weapons program. This resolution, importantly, also requested the Office of the High Commissioner for Human Rights to prepare an updated comprehensive report on human rights in North Korea. This has been an important step since the 2014 COI report, but it's not quite enough. However, we've seen that this resolution and other positive steps are the result of strong efforts from the CSO community and the defector community, and we need to make sure that we continue to listen to these voices and have a community and survivor-centered approach in all accountability and advocacy efforts. On that note, it's a great privilege to introduce our first panelist today, Mr. Lee Chul-eun, who's with us today. He's a North Korean defector who has direct experience working with the North Korean security apparatus. He's worked at the Wonsan Port Ministry of State Security in Kangwon Province from 2004 to 2006, and at the Information Bureau within the Provincial Ministry of the State Security, which is called the MSS, which is a similar, it can be compared to the Gestapo, North Korean version of the Gestapo, which he will talk about, in South Hwanghae Province in 2014 to 2016. He was serving there. Mr. Lee left North Korea and arrived in South Korea in 2016. He will offer us a rare insider's account of the inner workings of the North Korean Systematic Commission of International Crimes at home and also abroad. We will have Mr. Lee's translated presentation here on the screen in English for us to read. Thank you, everyone, and thank you, Mr. Lee.
안녕하세요. 저는 2016년 9월 바다를 헤엄쳐서 북한에서 탈출해서 남한으로 온 이철훈이라고 합니다. 반갑습니다. 오늘은 북한에서 김정은과 그의 권력을 보위하는 비밀 경찰인 보위부에서 근무한 경험을 토대로 보위부의 조직과 운영 실태에 대해서 설명하고자 이 자리에 왔습니다. 저는 2004년부터 2010년까지 강원도 원산원 보위부에서 배와 인원을 단속하고 검열하는 일을 담당했고 2014년부터 2016년까지 황해남도 보위국 정보국과 청담군 보위부에서 근무하였습니다. 도 보위국은 통상 시와 군 보위부를 통제하고 지도하는 역할을 담당하고 있으며 그중 제가 속했던 정보국 2국은 일선의 정보원들을 포섭해서 동향을 탐지하는 부서입니다. 이 외에도 사건을 종합해서 상급기관에 보고하는 종합국 1국 그리고 또 해외 출입을 한 주민들을 사찰하는 반탐국 3국 사건을 수사하는 수사국 4국 피신자를 조사하는 예심국 5국 등 여러 것이 있습니다. 기본적으로는 시군 보위부 수사국에서 기초조사를 진행하고 예심부터는 도 보위국에서 사건을 이관하여 진행하게 됩니다. 이는 전국적으로 동일한 체계입니다. 도 보위국 구금에서 예심 과정 중 정치범에 해당된다고 판단되면 사형이라는 법적 처벌조차도 가하지 않고 관리소로 보내집니다. 관리소로 보내는 것은 그 사람을 죽이지도 않고 살아서 평생 강제 노역을 하며 김정은 원수님께서 이끄시는 사회주의 조선을 보라. 즉 생지옥을 맛보게 하는 것입니다. 관리소 안에서 고통 속에서 죽게 만들도록 하는 것이 기본 임무입니다. 북한의 보위원들은 보위원이 직접 주민들 속에 침투하여 그들의 사상 동향을 알아봐야겠지만 그들은 사회 공포 조장을 위해 존재를 드러내고 다니면서 일을 하는 탓에 일반 주민들 속에 침투할 수 있는 정보원을 포섭하는 것이 중요합니다. 전국적으로 보위원이 한 10만 명 정도라고 하면 그중 단위 이상의 상급기관 관리 보직이 3만에서 4만 정도, 시군 단위 집행기관 보위일꾼이 6만에서 7만 명 정도라고 보시면 될 것 같습니다. 일선 보위원 1명당 30명이 넘는 정보원을 두기 때문에 최소 250만 명을 넘는 주민들이 정보원이다라고 보시면 될 것 같습니다. 정보원 1명을 포섭하기 위해서 당에 충실한 사람 중 사고 수준을 보며 탐색을 하다가 한 사람에 대한 사상 검증을 1년 길게는 또 3년 진행을 합니다. 정보원이 될 만한 사람들을 밤에 단독으로 사무실에 불러 당과 조국과 인민을 위해서 불순분자를 색출해 내는데 일을 좀 해야겠다라고 제안을 하면은 이 일을 거부하는 사람은 없습니다. 이들을 포섭함과 동시에 2박 3일 동안 제작된 교육 영상을 통해 이전에 사건 교육을 하면서 업무 전달 및 사상 강화를 시키고 이후에도 정기적으로 1년에 한 번씩 교육을 진행합니다. 보위기관의 요시찰 대상을 설명해주고 정보원이 자체로 이를 색출해낼 수 있게 교육을 합니다. 통상 보위부가 일반 주민 사이에서 단속하는 행위는 미신행위, 간첩행위, 한국 드라마 시청, 마약과 속록한물, 관련 행위 등이 있습니다. 형법 조문에 나타나는 행위와 연결시켜보면 수뇌부를 제거하려고 하거나 당 일꾼을 위해하려고 하는 경우에는 테러죄 제62조나 파괴암해죄 제65조, 한국의 돈과 연루되거나 정보를 파는 등의 적과 내통하는 적선행위는 국가전복음모죄 제61조, 국가반역죄 제63조, 간첩죄 제67조에 해당됩니다. 종교행위, 미신행위는 물론이고 말반동, 자살, 또한 지도자와 당에 반하는 행위로 반국가선전선동죄 제66조에 해당됩니다. 형법과 형사소송법을 참조하지만 실질적인 보위부의 처벌 근거는 보위부 내 보위사업지도서라는 별도의 내부 지시서입니다. 전국 보위기관에 배포되는 보위사업지도서에는 부서별로 어떤 업무를 해야 하는가, 어떤 사건을 어떤 범죄로 처벌할지 세세하게 정리되어 있습니다. 형법에는 구체적인 내용이 없기 때문에 일반 인민들은 보위사업 지도서에 나온 내용을 알 길이 없습니다. 특히 김일성 수령과 김정일 동지, 김정은 위원장, 김씨 혈통에 대한 위상을 시비 증상하거나 업적을 훼손하는 자들이라는 단속 대상이 세부적으로 적혀 있는데 김씨 혈통에 관한 적대적인 입장을 취하는 행위도 함께 적시해두고 있습니다. 예를 들어 김정은 위원장에 대한 비판이나 위신을 깎아내리는 낙서는 처벌 행위는 관리소 행위입니다. 낙서 범인을 잡기 위해 모든 주민들이 학교 시절부터 필적을 써서 제출하도록 되어 있습니다. 종교 행위의 경우 비밀 처형을 하는 경우도 있습니다. 주민들의 종교의 존재를 인식하는 것을 막기 위해서 인식하는 것을 막기 위해서입니다. 그 시신은 매장도 하지 않고 불태워진다고 합니다. 자, 보이사업 지도서에 근거해서 김정은을 비방하는 사람들이 발견되면 보이부는 정보원을 통해서 그 사람을 주시하다가 어느 정도 사건이 누적되면 불시에 체포합니다. 특히 김정은이 내려보내는 방침이 떨어진 직후 시범격으로 걸려들면 그 시기 적발된 자들은 더욱 가중처벌되는데 인민들은 이러한 상황에 미처 대처할 방법이 없습니다. 보위원은 항시 특별 긴급수사권을 보유하고 있기 때문에 언제 어떤 것이든 법원의 영장 없이도 긴급수사 가능한 권한을 가지고 있습니다. 일단 보위부에 체포되면 조사 단계에서부터 어디에 구금되어 있는지 가족들에게 고지가 되지 않습니다. 사건이 해명되지 않아 보위부 구금소에 들어가면 법령상의 예심 기간이 준수되지 않아도 아무도 이의를 제기할 수 없습니다. 문제는 내적 잣대는 분명히 있지만 담당 수사원이나 예심원이 처벌을 정하는 과정에서 명확한 기준을 잡기가 모호하다는 것입니다. 수령보위라는 미명을 보호보위부의 예심 단계부터는 쉽게 건드릴 수 없는 영역이 되는 것입니다. 장기적으로 구금된 상태에서 고문당하다가 죽더라도 가족들은 그에 대한 해명을 요구할 수 없습니다. 변호사가 있긴 하지만 실상 법적 구조 조치는 전혀 없다고 할 수 있습니다. 재판 또한 유명무실합니다. 보호보위국 예심에서 내려진 결론이 평양의 국가보위성에 올라가면 대부분 그대로 집행하시오 라는 명령이 내려옵니다. 일부 당적 배경을 가진 자들을 제외하고 재판은 전혀 공개되지 않아 어떻게 진행되는지 알 수가 없습니다. 국가보위성의 특별재판소 판사들은 평양 양정을 고민할 여지 없이 구색을 맞추기 위해 존재합니다. 판사들을 또한 국가보위성의 성원들이며 독립성이 없는 당과 김정은을 위한 재판부입니다. 과거에 비해 정치법으로 적발되는 사건의 수는 적지만 이미 잡힐 사람들은 잡혀 정치범으로 되어 있기 때문입니다. 보위기관의 처벌 기준과 운영 방식은 장기적으로 유지되고 있고 굳이 일상을 침해하는 사태를 피하려 애쓰며 인민들은 스스로 알아서 정치범이 될 행위를 피하며 살아가고 있습니다. 이러한 현실을 두고 나온 저는 북한 밖에서 할 수 있는 일이 없는지 이 자리에서 여러분께 질문드리고 싶습니다. 경청해 주셔서 감사합니다.
Thank you very much, Mr. Lee, for your presentation. Hearing from those with direct experience within the regime demonstrates the systematic, complex and secretive nature of the crimes and gives us more insight into the security structures behind the Commission. It's so important to hear from the survivors themselves, so thank you for your address, Mr. Lee. I now turn to our second speaker for today, Ethan Hee-Seok Shin, a legal analyst at TJWG, our partner organisation. Ethan has been interviewing North Korean escapees in South Korea to record enforced disappearances and other grave human rights violations and for a number of years, and has made numerous submissions to UN human rights mechanisms, including the UN Working Group on Enforced or Involuntary Disappearances. He's helped set up Footprints, an online database that documents and publishes information concerning reported cases of arbitrary detention, abduction and enforced disappearance disappearances committed in North Korea. He's an advocate for reform of the South Korea's joint interrogation procedure for the newly arrived escapees from North Korea, and also advocates for South Korea's domestic implementation of the International Convention for the Protection of All Persons from Enforced Disappearance. Ethan holds a Master's in Law from Harvard, and his work has helped TJWG become one of the leading organizations internationally on abductions, arbitrary detention, and enforced disappearances and other mass atrocities committed by the DPRK regime. Thank you, Ethan. Over to you.
Sorry. Thank you, Lizzie. I would like to first thank the Republic of Korea government and our good partner GRC for co-organizing today's side event. And I would also like to thank all of you for coming here at this early hour to take interest in this important topic. So to give a brief introduction of my organization, Transitional Justice Working Group, we were founded in 2014, actually right after the publication of the landmark report from the United Nations Commission of Inquiry on the human rights situation in the DPRK. We have been researching the topics of enforced disappearances, public executions, and also the risk of radiation exposure from the North Korean nuclear test site. On the back, we actually have a number of public reports that we have published recently and also in the recent years. So please feel free to take them if you're interested. So I would say any discussion about accountability for North Korea's atrocities and other international crimes would usually begin with the 2014 COI report that I just mentioned. And the COI report actually found the 6 different categories of crimes against humanity that reportedly have been taking place in North Korea, namely the crimes taking place in the political prison camps, 관리소, and also in the ordinary prison camp or in prisons, and also the crimes committed against the religious believers and other people introducing subversive influences, quote unquote, and also against North Korean refugees and the other foreign citizens abducted or disappeared by the North Korean government. This is just a chart of the inhumane acts that were cited by the COI DPRK. So, with regard to these crimes against humanity, the COI made the recommendation that the UN Security Council should refer the situation in the DPRK to the ICC. And this recommendation was backed also by the UN Human Rights Council and the General Assembly in the same year. But as we all know, the Security Council has failed to act on these recommendations, mainly because of the Russian and Chinese veto. The COI also did briefly mention the possibility of genocide being committed in the DPRK. But it didn't really actually go into the more substantive aspects. And it basically stated, as I quote here, that such crimes as the atrocities committed in the political prison camps, for example, against political prisoners, might be described as politicide. But in a technical sense, observers would question why that conduct would detailed about was also would amount to genocide as well. And basically the commission concluded that there is insufficient evidence to back the claim that genocide has been taking place in North Korea with respect to the religious persecution and other political persecution that have been taking place in the country. So when we have this discussion about how to proceed with the ICC and ICJ accountability options for North Korea, I would say one of the first questions that might arise is is it even feasible to collect information or evidence about what's happening in North Korea, given the very close nature, the extremely close nature of North Korea? And this is the challenge that the problem that our organization TJWG has been grappling with for the past 10 years. But we have been able to identify a number of the important institutions that are responsible for these crimes against humanity and other great human rights violations in North Korea. We mainly relied on the information provided collected by our interviews with the North Korean escapees in South Korea. There are over 34,000 of them, and they have been a very important source of information, not for TJWG, but for other important accountability work as well. And we have been collecting this kind of in-house data based on our interviews with the escapees. And we are also expanding our work to the more open source intelligence network data, including the news reports and the other information that are publicly available. So for our public execution report, we have been asking the North Korean escapees to pinpoint the locations of the public executions that they have witnessed. At the same time, we've asked them to locate the location of the MSS and other security organs offices, local offices in the country. So this is just one example in the city of Haesan in North Korea. And we have been collecting this kind of information over the years. So in the process, we have been able to identify these MSS headquarters in Pyongyang and the provincial and the other city and council level offices within the country. So these are the coordinates that are plotted in the map. We have also been creating the database of the victims, perpetrators, and the legal proceedings related to the forced disappearances and the abductions committed by North Korea. And this is actually a website that's that we created, which in partnership with other NGOs basically puts together the different information sets and makes it easier for the academics, for the journalists, and also for the general public to find and access information with respect to these cases. So these are the kind of information that we've collected from our interviews with the enforced disappearance victims as well. And it's in Korean, but it basically plots the locations of where these enforced disappearances and abductions are taking place, and also like the location of the last places where they were seen, with the time or the time period when these disappearances occurred. And this set of information can be combined with the information about the people who are in charge of the MSS and other state organizations at the time, to establish legal responsibility in the future. In terms of the OSINT or the open source intelligence, we have been collecting information from a few news outlets that actually have sources or informants within the country. Daily NK, RFA, VOA, Asia Press. These are the media outlets that do have this kind of sources within North Korea. And they actually they have a lot of reports about public executions and disappearances and other human rights violations taking place in North Korea. So again, we have been creating Excel files to make it easier to see the time and location of these different reported incidents of human rights violations. Interestingly enough, the North Korean state media can also be a source of information especially for the people who are very high up in the echelon. So this is the Rodong Shinmun, or the Worker Daily, the Labor Daily, which is the main publication of the Korean Workers' Party, and it actually, for example, has like the party functionaries who attended a major conference hosted by the party, and the information that's listed here can also be used to create a list of the potential people who are in the chain of command. The South Korean government also publishes the dictionaries or files about the top officials in North Korea. So that has also been an important source of information. Again, we have been plotting all the information into the Excel sheets for this kind of data collection purposes. And last but not least, there are also because North Korea has been developing nuclear weapons, there have been numerous sanctions slapped by national authorities by different governments, including South Korea, Japan, the U.S., and the European Union. So that has also been those sanctions lists. That lists the individuals and entities have also been a very important source of identifying the potential perpetrators of these crimes against humanity taking place in North Korea. Again, that's the kind of information that we've been plotting in the collecting the Excel spreadsheets. Now you might also wonder, given also the very close nature of North Korea, what good does this kind of accountability or advocacy efforts do? What kind of benefits, what kind of differences can it make in North Korea? But interestingly, earlier last month actually, there was a North Korean diplomat who recently defected to South Korea, and he actually published a dozen diplomatic cables that he brought with him when he defected to the South. And this gentleman, Counselor Lee Gyu, he used to work for the North Korean embassy in Cuba. That was his last posting. And his 12 diplomatic cables revealed that, interestingly, all the discussions at the UN and other international forums are reported personally to Kim Jong-un, the Supreme Leader, and he personally gives directives or orders for his diplomats on how to respond to these issues. So these discussions at the UN, at the ICC, and other international institutions definitely have his attention, and they are actually very sensitive about this kind of international criticism or discussion of the North Korean human rights record. And it was also made clear from these diplomatic cables that the North Korean government has taken the ICC referral recommendation from the COI very seriously. So again, it really shows that they have been strategizing to find kind of counter this kind of international narrative by aligning with Russia, China, and other countries. So it's probably safe to say that there is some leverage and there is some positive influence that can be realized by pursuing this kind of accountability avenues with respect to North Korea. So with respect to the ICC, as I mentioned, the COI report specifically recommended that the UNSC take action to refer the situation to the ICC. Unfortunately, this has not happened, as I mentioned, because of the threat of the Russian and Chinese veto. But as we know, there was an attempt back in 2014 for the UN Security Council to refer the situation in Syria, which was vetoed by China and Russia at the time. But there have been recent calls for the UNSC members to consider at least putting this resolution to a vote. And even if Russia and China, as most likely, veto this resolution, it will force them to publicly ally themselves with the North Koreans, and also have to explain their position at the General Assembly according to the new rule that was adopted in 2022. Even though the UNSC avenue seems pretty difficult, there are other ways to find jurisdiction, ICC jurisdiction, with respect to North Korea. And as you know, the Bangladesh-Myanmar case with respect to the Rohingya kind of set this new precedents that may be encouraging. And again, in the Rohingya case, the ICC basically the prosecutor have recently applied for an arrest warrant for General Min Aung Hlaing. And the main charges involve the crime against humanity of deportation and persecution on ethnic and/or religious grounds. The third charge that was not really addressed but was recommended by the pretrial chamber in the past concerned other inhumane acts, namely the infliction of great suffering or serious injury by means of intentional and severe violations of right to return of displaced persons. And these charges can actually be applied, for example, with respect to the North Korean escapees who have settled in South Korea. I would say it's very difficult at this point for the prosecutor to open pro motu investigation. But as we have seen recently, the state referrals of the situation in Ukraine, Palestine, and the most recent one brought by Lithuania, the Belarus situation, again offers the opportunity that other countries, other states parties, may also refer the situation in the DPRK to the ICC if the jurisdictional and legal grounds can be found. And again, in the Belarus case, the main, although the full details of Lithuania's submission was not made public, it did cite the crimes against humanity of deportation, persecution, and other inhumane acts, which is basically, I guess, similar to the Rohingya case. And so applying all this to the DPRK situation, there actually have been a number of submissions made to the prosecutors, the Office of the Prosecutor. For example, in the case in 2010, there was an armed military attack from North Korea against South Korea. There was a preliminary examination, although it concluded that the scale of the crime did not amount to war crime. But it does leave the open possibility that if there are future military attacks, God forbid, it might actually be something that the ICC can claim jurisdiction. And also with respect to the North Korean workers who have been dispatched to Poland, Russia, China, there have been submissions made by NGOs. Again, the Office of the Prosecutor concluded that, at least with respect to the claims of forced labor, enslavement, or other human rights violations committed against the North Korean overseas workers in the states parties to the ICC, those crimes would not amount to the crimes against humanity. But with respect to other situations like in Russia or Ukraine, it is certainly still a possibility, I would say. And also, again, going back to the Rohingya refugees case and also the Belarusian case, because we have over 30,000 North Korean escapees in South Korea who are also exposed to this kind of persecution and other inhumane acts. And that's something that an avenue that should be explored. More recently, as you know, the North Korean government has deployed military units to the Ukraine war, and this has obviously going to grab a lot of international attention. And with respect to the crimes against humanity or war crimes that are committed in the Ukrainian territory, the ICC can again claim jurisdiction. The news reports thus far point to the North Korean troops being sent only to the Kursk front, which is in Russia proper. But if there is any evidence or information that North Korean troops have been sent to the Ukrainian territory currently under Russian occupation, and if they are actually taking part in war crimes or crimes against humanity, that can be a ground for the ICC claim jurisdiction as well. And this the South Korean government officials, as well as the European Parliament, have actually made statements referring to this possibility recently. So in order to actually realize this kind of the ICC avenue, I believe we will need to collect more information about these different possible cases. And also, it will be crucial for the Office of the Prosecutor to also look into this matter more closely. With respect to the ICJ, the International Court of Justice, interestingly enough, North Korea has been a state party to the Genocide Convention since late January of 1989. And when it ceded to the convention, it made no reservation to the dispute resolution clause, which means that any other states parties can institute proceedings against North Korea at the International Court of Justice for possible violations of the Genocide Convention. Now, obviously, this is not an easy case to make in purely legal terms. Because the bar for proving genocide is very high. You actually have to prove that there was a genocidal intent to destroy in whole or in part a national, ethnical, racial, religious group as such. And with respect to North Korea, it's not the possible the protected groups covered by the Genocide Convention. We have identified two main groups. One, the Christians and other religious believers in North Korea. Secondly, the North Korean refugees who are sent back from China when they're pregnant. These pregnant women are subjected to the forced abortion, and if they do have babies, those babies are killed in this by the North Korean authorities. Mainly because the North Korean government wants to maintain this kind of pure Korean race in the country. So these are possible, I guess, grounds for the genocide case against North Korea. And in light of the recent genocide cases and also cases brought under the Torture Convention and the CEDAW Convention that is being contemplated, perhaps this is another avenue that we can pursue. And again, in order to realize this kind of ICJ cases, it will be important to first collect more information, especially with respect to the persecution of religious groups. It spans almost 70 or 80 years of the time period of North Korea's existence, and interestingly, some of the statements made by the North Korean leaders and also the internal documents of the North Korean government do point to this kind of the clear intent to destroy any religious groups in the country. Similarly, with respect to the returned North Korean pregnant women and their babies, it will be important to systematically collect the statements from the doctors who are involved in this procedure, and also to find the documents that will add to the case that this was a deliberate genocidal intent on the part of the North Korean government or officials. So all this to say that the justice and accountability options for North Korea it's very difficult, but there is some room for possibility. And if you have any questions, I'd be happy to discuss them later. Thank you.
Thank you very much for your address, Ethan. You clearly outlined the challenges there with both the ICC and the ICJ, but some potential opportunities, particularly with the cross-border jurisdictional decision with the Bangladesh and Myanmar situation, and also the developments with North Korean troops potentially involved in the Ukraine conflict. And then also at the ICJ with potential breaches of the Genocide Convention or the Torture Convention. So thank you, Ethan. I also want to note that some of the work that TJWG have been working on can be collected there. There's a few reports there at the back table, so feel free to collect some if you're interested. I'll now turn to our third speaker, Catriona Murdoch, who kindly stepped in last night in place of our Republic of Korea representative who could no longer be here today. Catriona is a UK barrister and has been the GRC Vice President since 2020. She has over 15 years of experience in international litigation before the ICTY, the ICTR and the ICC, advising on crimes arising out of the Rwanda genocide, the Iraq War, and the war in former Yugoslavia. She's been working on the DPRK human rights context since 2020. Thank you, Catriona.
Thanks, Lizzie. I want to start by saying thank you to our TJ colleagues who are here supporting with cameras, translation, and all other aspects, including Yeji as well, and also to Mr. Lee for his courage in speaking today. I think, as Lizzie said, it is a unique opportunity to hear this kind of information. As Lizzie mentioned, I came into this event last night, so please allow for this to be a little bit more rough and ready than I would have usually hoped for. It's always a hard act to follow Ethan in these panels, so I will do my best. The DPRK is, as many of you know, and I think some of us working in this space, is an international blind spot. The response and international attention that this situation gets is unlike many of the others that we work in and may be aware of. When we consider the extreme crimes that are occurring on a daily basis inside North Korea, some of which have been highlighted today, this blind spot remains a serious challenge. Yet, despite this, the event and the title of this event was framed in a deliberate way because there do remain opportunities. As Lizzie mentioned, this year marked 10 years for the Commission of Inquiry report. It was a landmark report and in my view remains one of the best Commission of Inquiry reports I've come across, both in its forensic analysis, its breadth, and most importantly in its recommendations. Lizzie mentioned the quote from the Commission of Inquiry, and I do just want to restate that the situation in North Korea is without parallel in the contemporary world. In this environment, especially in the corridors here, competing for space, saturated with tragic stories, there is very often very little oxygen left in the room for North Korea. Many of you will know, attending these panels, where double standards have been called out and pleas for attention rightly raised. But I hope that this event this morning, and I'm grateful for you getting up early for it, really shows why this deserves our attention, even if just for this morning. Global rights compliance are relative newcomers to the North Korea space, and we've been working on this since 2020, when Wayne Jordash and I were representing and advising the family of Otto Warmbier, who, if you don't know, was a 22-year-old American student who took down a propaganda poster in North Korea when he was on visiting there in 2015. He was arrested and sentenced, quite like as Mr. Lee described, in secret, to 15 years hard labour in one of the camps. He was returned after intense diplomatic activity in America in a vegetative state and died about 2 days after arriving home to the US. There was clear signs of torture in his autopsy and medical reports. So we started there, and we've been privileged to partner with a number of Korean organisations, of which our long-standing partner, Ethan and colleagues. The DPRK is without parallel, not just in terms of its crimes and the dystopic regime that we've heard about, but also in terms of the accountability landscape. And we've often heard, time and time again, that we can't, and that the pathways are far too difficult. Sorry, I'm always too softly spoken. With many of the situations that I've worked on personally in global rights compliance with colleagues who are here, a pattern emerges, a situation escalates or a new situation emerges, international attention will follow, CSOs will rally together, documenters will come, advocacy increases and accountability is called for, and we see that pattern up and down the corridors of the ASP each and every year. I hesitate to say fortunate because I don't know what can be fortunate about being embroiled in a conflict where your people are maimed, tortured or starved. But in some situations, from that horror, there are some, more often than not, through the tireless work of those documenting, a few willing states and a few good lawyers, the seeds of accountability can be planted. A commission of inquiry may be established, a mechanism may arrive, a state referral to the ICC, an arrest warrant may be sought, an arrest warrant may be issued. And whether or not those seeds of justice, whether or not they flourish, they represent hope. And I think as one Syrian panelist I heard, I think he's here, I saw him earlier, said on Monday evening, justice is not the verdict, but the whole process. And again, for DPRK, this pattern is not paralleled, it's not the same. And without seeking to diminish the role of many of the Korean CSOs we've worked for, who lobbied for the Commission of Inquiry in 2014 and before, for those of us in the ICR space, this commission kind of came out quite quickly and emerged in a different way. Again, unlike many of the other commissions some of you may work with or engage with, this one was short. A lot of these commissions, they take time to build, often to the dismay of survivors and civil society. They will start more cautiously with some very veiled and arguably unsatisfactory findings. Again, in the context of North Korea, what happened was a very long and detailed report that was issued with very clear, bold findings of crimes against humanity and an urgent call for a Security Council referral on the situation to the ICC. Again, in many ways, another aspect to DPRK that is different is the sources and information. We've heard from Mr. Lee this morning. Again, in many of the cases that we've worked in, and some here I can recognise from Yugoslavia and Rwanda days, access to insider witnesses is incredibly rare. And in the cases that I've worked on, those types of witnesses would attract a huge amount of interest, caution, and certainly opportunities for defence and prosecution teams. With the DPRK regime structured as it is, this is a really unusual information source where you have witness, perpetrator and survivor blending sometimes in one person. Again, challenges and opportunities with that. 10 years since the Commission of Inquiry report, with the establishment of an OCHR office in Seoul, there remains a lot of can'ts in this situation. There has been no Security Council referral, and despite much documentation and attempts at accountability, the community awaits more international attention. The stakes and optimism were raised really high in the beginning, and the process of those 10 years of very little action has been incredibly difficult for those working in this space. So in light of that, when we started as GRC in 2020, what we realised was that there was no comprehensive analysis or understanding of what pathways were available, domestically or internationally. So after a year or so of research and consultations with community and with OHCHR, we produced an accountability strategy report. I think there are some copies maybe of the short one at the back. And that identified 9 different pathways, and we grouped them into hard and soft law, long and short term, and then we assessed the merits and accountability options of each. You'll be pleased to know, I'm not going to go into the technicalities of anyone. Ethan has done that beautifully as always, and we have Rod coming after us, who's going to touch on a little bit more these opportunities. But in short, we looked at UJ, ICC, sanctions, ICJ, and long before some others considering this, we looked in 2020 about how CEDAW could be used before the ICJ to initiate proceedings, given particularly again in this context the extreme nature of violence against women and girls in North Korea, and the fact that the majority of women who are able to escape, that majority of people who are escaping are women. It will be no surprise, as Ethan has articulated, one of the pathways that is of most interest is the ICC. And again, some more can'ts along the way there. It's not an easy pathway. As Ethan has articulated, the North Korea is not a state party. Security Council referral is unlikely, and temporal jurisdiction for many of the crimes in the context of enforced disappearances is challenging because they occurred prior to 2002. But in the auspices of this court, we would still like to encourage pragmatic optimism and creativity, and to encourage the wider tentacles of this court to consider how we can support and champion what is happening inside North Korea. As Ethan mentioned, the deployment of troops, potentially or otherwise, and as we'll hear from Rodney in a moment, into the unlawful Russian aggression against Ukraine presents opportunities and pathways, and we're exploring those in our current project together with Ethan and colleagues. We really do need to work creatively and collectively to bring international criminal law to its full potential in this space and shine more light on this blind spot. On a personal note, my mother drilled into me and my brothers from a young age that there is no such word as can't. I think we can pursue accountability in North Korea. There are pathways available, we've outlined them. But as with so many of these situations that we are hearing this week and these years, the challenge is not jurisdiction, it's political will. And so for a long time, I've held the view firmly that in the context of North Korea, the biggest opportunity and the biggest challenge, but the opportunity for this space and for colleagues like TJWG and Mr. Lee, who's bravely talking about and taking risks to document this, is to share these stories and combat that silence. And so I think that is our opportunity.
Thank you very much, Catriona, for your address and your pragmatic optimism too. I think it's very much needed when in this context where we see so many hurdles to the different accountability avenues, but we know that there are opportunities out there. I'm going to now turn to our fourth and final speaker, Rodney Dixon, who has shared with us a pre-recorded video today, so we have it up on the screen. Rodney Dixon is a UK barrister with broad experience in the UK and globally, specialising in public international law, international criminal law and human rights. He's appeared before all international courts, for governments, heads of states, victims groups, NGOs, etc. He's also worked in numerous national and regional courts, including bringing cases at the European Court of Human Rights, different universal jurisdiction cases, hearing proceedings, as well as actions before the International Court of Justice. Rodney is a co-author of Archibald International Criminal Courts, Practice, Procedure and Evidence, and was a senior research fellow at King's College London. I'll now turn to Rodney.
Good morning, everyone. I'm very sorry I can't join you today at your side event. Unfortunately, I'm stuck in court proceedings and can't be there. I know this side event is exactly about how one can bring court proceedings for accountability in North Korea. So I wanted to nevertheless send this recorded statement about some of the available channels and options. And I hope that this will assist in your discussions, and I look forward to hearing about how they went, particularly with the insider evidence that I know you're very fortunate to be able to have there today to consider. The situation with North Korea is one that has only been escalating and spiraling out of control over many, many years now. It's one of those ones that leaps out for international justice, but because of a number of the obstacles that are often there legally, it's not a straightforward task. I know you're going to be applying your minds to that today, and we do need to think creatively about ways of being able to seek accountability. It's good that you're all there at the ASP, because that's where many states and non-state actors gather, and I would encourage you all to brainstorm widely about the ways in which this could be taken up. Very often the work of these kinds of gatherings only focuses on certain of the main cases that are being taken up, and of course that's very important. There are some appalling situations at the moment that have to be focused on, but equally it is so important that the state parties and the court look beyond those situations to other ones. It can't just be that we have a limited amount of space on the agenda and then everyone else gets cut off. We need to ensure that all efforts are made to include all situations that are appropriate. And the one of North Korea certainly is. As I'm going to highlight, particularly because it crosses over with a number of existing situations at the moment, and that gives rise to unique possibilities that must be seized upon. I want to start with the ICJ first. I'll come on to the ICC next, but the International Court of Justice has seen a blossoming of cases where states have been seeking advisory opinions, but also looking at exercising their rights against other states because of convention and treaty violations. This is very encouraging, and I think it means that for the situation in North Korea, there are equally possibilities opening up and ones that must be explored. Of prominence, of course, is the fact that North Korea has now joined the conflict on the side of Russia in Ukraine. Ukraine currently has a case in respect of genocide against Russia at the ICJ, and I think serious thought should be given to joining North Korea in that litigation. That is litigation that is only at its early stages, and there are possibilities because of North Korea's recent dipping in to this conflict and what the consequences of that are going to be. It's a serious involvement, and all the indications are that it's going to be long-lasting. And that therefore means that where there's jurisdiction already established at the ICJ, it would be a lot easier to, if it was possible, add North Korea into that. Starting wholly new proceedings is possible, but much more challenging. It is possible for a collection of states, as has happened in other situations, or even one state supported by others, to look to bring North Korea to the ICJ, specifically in relation to concerns that apply to the genocide convention. Of course, the necessary evidence has to be explored and gathered, but it does seem that there's a jurisdictional basis there for pursuing that option through the genocide convention itself. There are very few other options available. Unfortunately, it doesn't mean that we shouldn't look at all of them, but that one presents one of the main possibilities, and as I say, particularly because there's already a case now open. There are very few other possibilities outside of the ICJ in the UN system, because North Korea has not agreed to allow for individual complaints to be brought. However, that doesn't mean that matters cannot be taken to the UN, as has happened previously with the report from 2014. But that needs to be followed up. There are many channels through the UN Human Rights Council, through the special rapporteurs, and through the General Assembly that need to be used to ensure that, as far as possible, investigations can take place, findings can be recorded and made, and even if they're not binding, they are there for the record and they could potentially be used further down the line. They also serve as a record and as a reminder. It provides some justice to the victims and some potential deterrence to the authorities as well. Turning to the ICC then, the options have increased, particularly because, as I've underlined, North Korea has now joined the conflict in Ukraine. It's already a situation open for Ukraine where charges have been brought against Russian officials. So even though Russia is not signed up, their nationals who are alleged perpetrators have been charged because they are coming on to the territory of an ICC state, namely Ukraine. And if North Korea does the same, either its troops being there, or even if its troops are not there, if they're part of the common plan together with Russia to commit crimes on ICC state party territory, then they could be investigated alongside the Russian officials. And even though they're not signed up, they could be charged as well. So there are some very significant opportunities there, depending on the evidence that can be gathered. And here I highlight again the potential insider evidence that you're going to hear about. That and other evidence to be gathered in order to mount a case that could be brought at the ICC against North Korean officials for their involvement in crimes committed in Ukraine. That is a serious avenue that is opening up. Of course, cross-border efforts into other ICC countries is a possibility as well. It's not limited to Ukraine. We could also look at South Korea and other countries, but we have to bear in mind, as I've stressed before when talking about this topic, that nothing is open yet. We don't even have a preliminary examination, and much harder to get something new opened, given how full the ICC's docket is, than rely on something that is in existence already. I'm not saying we shouldn't try other cross-border crimes where, although the crimes are committed from North Korea, they continue into a country that is signed up, and that gives the court jurisdiction. I'm not saying we shouldn't look at those options, and one can file Article 15 submissions in that regard. Many have been filed in other countries, many are being considered. But it does mean that it might take longer. If you've got to get the attention of the prosecution first, you've got to get a preliminary examination open and then take it from there. I'm not saying that we should discount those. Those should be looked at as well. All avenues to pursue justice should always be taken into account. But I think greater consideration right now, urgently, should be given to the situation of Ukraine and North Korea's involvement in that one. I think it's a golden opportunity that should be seized. So those are some of the main avenues that do need to be explored, and I'm very encouraged that this is on the agenda and is part of the ASP discussions. Do raise it loudly to the rooftops while you're there, and I'd be very interested to see what response we are getting from the Office of the Prosecutor, from state parties. Going back briefly in conclusion to the ICJ, the very well established Barcelona traction case, that's from 1970, Belgium versus Spain, established the erga omnes principle, and that was that there are certain fundamental standards that apply to all states, where states have to uphold their obligations in relation to all other states, in particular in relation to the commission of genocide, the continuation of slavery, and very serious crimes like torture. These are some of the core erga omnes standards, which all states are bound not to violate, and to protect other states collectively from having themselves be subjected to those violations. This is a long-standing principle, and it should inspire and guide us in our work at the ICJ, yes, the options that I've raised there, but also at the International Criminal Court, where one would look at individual criminal responsibility. Universal jurisdiction options are also there, although the authorities don't travel very often, but they shouldn't be left out of the equation, because sometimes that does happen, and it might happen more in the future. So my touchstone here is to leave a message of some hope, I think, that because of all of these various avenues that are opening up, there will be the possibilities for pursuing justice. It's not going to be an easy course, but those options are there. And I do think that serious thought, particularly while you are at the ASP, should be given to acting now in relation to Ukraine. I do want to emphasize that. Thank you very much for listening to me, and I look forward to hearing the outcomes of what happened. Thank you. Bye-bye.
Thank you very much, Rodney, for that address. In the interest of time, I want to just open up the floor to questions for our panelists, as we've only got no minutes left. So if there's one or two questions, perhaps we can take that. Yes.
Thank you so much, Nout van Woudenberg, Kingdom of the Netherlands. It's not a question to one of you specifically, but you all mentioned, or almost all mentioned, the North Korean soldiers being sent to Russia to fight against Ukraine, and I have two questions on that, or a question and a remark. First, do we know more about it? Are we talking about conscript, elite troops, or maybe victims of repression that are being forced sent there? So what's the composition of the group? And second, I was wondering, how should we see it? Should we see it merely as an escalation or as a political move? Because, I mean, they do not know the territory, they do not know the language. So I'm basically wondering what's merely behind it, so to say. Thank you.
Thank you. And we might take one other question if we have time. Yes, Nadezhda.
Thank you so much. That was really insightful, particularly to Mr. Lee. I'm embarrassed to say that I don't know much about this context, so I really learnt a lot. My question is, it was interesting to see the diplomatic cables, because my assumption was that the government was just impervious to criticism, but it sounds like they rattled a little bit, so I'd be curious to know more about that. And then also the prospects of individual criminal responsibility when so many high-level individuals are sanctioned. What's the likelihood that someone will actually be able to travel and be arrested and then front a court in person?
Thank you. I might hand over to Ethan.
Sure.
Okay.
All right. Thank you for both excellent questions. So, with respect to the North Korean stationing of troops in Ukraine, I would say that it's a very cynical arrangement on both Russian and North Korean government's part. As you mentioned, there's not really much geographical or historical link between the two countries, but North Korea is basically a pariah state, has been for the past few decades, and Russia has kind of joined that league. So they kind of see this kind of mutual interest in like North Korea providing first military weapons, now troops sent there to fight alongside Russia, and most likely Russia will provide military technology, especially for the missile program that North Korea has. So it's basically a tit-for-tat arrangement. There's no any other like political incentive behind it, and the units that are being sent to the front, they're not like political dissidents. They're actually the service members of the North Korean People's Army, and it has been reported that they are mostly from the elite crack units. And the total number is estimated to be 11,000, but it could grow more in the future. So yeah, I think that's the kind of arrangement that they've had. And with respect to the diplomatic cables, yeah, so they call it North Korean Cablegate because it's not so often that you get to see the inner workings or inner thinking of the North Korean state. But yeah, I mean, a lot of the facts that are there that were kind of verified, we kind of knew that as we can guess that they were there, but having this kind of solid documents to prove it, I think is so different. And I guess some of the interesting findings, other than the fact that Kim Jong-un is directly like involved in the reporting and response process, is that for example, with respect to Universal Periodic Review, in the first cycle, the DPRK actually refused to provide its responses. They basically rejected the whole process as directed against North Korea, even though all 193 UN member states are required to go through the process. And in 2014, just before they were about to have the second cycle review, the COI report came out, and it kind of dawned upon them, I guess, that this was not a smart strategy, even for North Korea's own good. So they basically pivoted to a more, I guess, traditional stance taken by countries like China and Russia, which is to argue that the UPR is good because this is universal, this is not targeting North Korea, but whereas the country-specific resolutions in North Korea or the special rapporteur, that's banned. So that's the kind of like the change that they made since then to align with their like-minded countries. So again, that was a pretty interesting finding, and if you're interested, I'd be happy to share the actual like 12 cables that were publicized as well. Thank you.
Yeah, and just briefly on the question on prospects, million-dollar question, I think. But I think what I would say in the context of that, and it's a question we get a lot in other situations as well, is why it's so important to document and preserve information now and to have your cases ready. And so I think in a lot of the contexts that we've seen, the political winds can shift very quickly. Accountability can happen quickly, despite very often the wheels of ICL moving very slowly. So it's very difficult to say what the prospects would be in this context, but I think what's really important is ensuring that you're ready when you have that opportunity. And I think with a lot of these similar situations, it's not a lack of information. We have the information. It's putting that in a way that is rigorously verified, accurately drafted, and ready when you need to. So the challenge, of course, with North Korea is many diplomats and state officials don't travel, and those that do may be less implicated in some of the higher echelons of what is happening. But I think there are opportunities, and as you rightly mentioned, there's a lot of interest around sanctions body. There's a very strong and long-standing UN sanctions committee on the North Korea. So they have a lot of information as well. So difficult to say, but yeah.
Thank you both. And just wanted to ask Mr. Lee if you have any final comments or remarks.
제가 이 자리까지 와가지고 북한에 대해서 이야기를 했는데요. 여기 계시는 분들이 북한이 저희가 북한에 대해서 외부로부터 계속 이야기를 하고 있는데, 북한은 어쨌든 북한 김정은 체제는 무너져야 하거든요. 왜냐하면 북한 주민들은 고통 속에 살고 있습니다. 근데 자기가 고통받는지 모르고 있습니다. 네.
Yeah, I just have one last comment. All I know is that North Korean regime should collapse because North Korean people are suffering at this moment every day.
아까 질문을 주셨는데 러시아 파병 문제도 나왔던 것 같은데, 러시아에 파병된 군인들은 전쟁터에 나가는지도 모르고 나갔을 수도 있습니다.
A lot of you showed interest on the matter of North Korean soldiers being sent to Russia, but my assumption is that the soldiers being sent to Russia, they didn't even know where they were going.
통제 속에서 갇혀 살던 북한 청년들이 생애 첫 해외 경험이 전쟁터라고 생각하면 어떨 것 같습니까?
Imagine you as a North Korean teenager or someone in their 20s and your first outside world experience is being sent to the wall.
그들에게도 자기들의 자유를 줄 수 있게끔 저희가 좀 노력을 해야 될 것 같습니다.
And we should do everything we can to let them experience what freedom is.
그것이 한순간에 되는 일은 아니겠지만 계속 전 세계적으로 북한에 대해서, 김씨 체제에 대해서 목소리를 높여준다면 언젠가는 북한 체제도 붕괴되는 날이 있을 것 같습니다.
We have a long way to go to see that day. However, if we collectively push and then seek accountability towards Kim regime, I am sure that one day it will come and North Korean regime will collapse.
전 세계 인권을 위해서 일하시는 모든 분들께서 남북 관계 문제에 좀 신경을 많이 쓰셨으면 고맙겠습니다. 감사합니다.
Thank you so much for coming today, and please keep a good eye on the Korean Peninsula issue. Thank you so much for coming.
Thank you, Mr. Lee. So although we see the road to accountability as a long one and not without significant challenges, there are opportunities for accountability which are exciting and novel through the ICC and the ICJ. And so this is cause for hope for justice and accountability for victims of the North Korean regime. Thank you for attending today, and apologies for going over time.